how did you pick your victims? How did you pick these people who are
There was no
alleging that you
victims.
assaulted them?
Ma'am, I'm just gonna, Rashawn, I just want to just make sure that we're focused. We'll get to you here in a second, but
Yeah,
I want to
but
make, I want to make,
understand.
no, wait a second.
Hold
So
on, sir. I understand. I just want to speak to what you're saying so I can help you understand.
I want you to stop.
I
want
do
you to
have
stop.
yell? Do you have to
Smith.
yell and be so aggressive
I want
towards
you-
me, sir?
Ma'am, I want you to stop or I will have you removed from the meeting because that's just the way this
There's
is. This
no
is a
need to
meeting.
be aggressive.
I'm
Aggression
just
is
saying.
not necessary. I'm
Okay.
trying to help him
Question is-
understand.
Wait,
From my
the
understanding,
question-
I'm here to be an
Ma'am,
advocate
ma'am,
for him, and he doesn't
Ma'am,
understand.
we're gonna end this meeting altogether with you if you want to continue.
But
We're
he
gonna be
doesn't
done.
understand, and
Mr.
it's my job
Smith.
to advocate for him, sir. There's no need to be aggressive.
Okay. And what's the saying? When you have friends like that, who needs enemies? We have covered thousands of parole hearings, and we have never seen an advocate get up and talk to the parole board in that manner. And by golly, I cannot imagine it's going to go well. Now, this man, he was sentenced for 2 convictions of SA. One on a girl who was developmentally challenged. They said that she had the IQ of about a 12-year-old, and the other was on a 57-year-old woman. DNA linked him to both of those crimes, yet he is going to insist on his innocence. Now, we have the appeals, we have the information on the case, so we will go through those facts to dispel any thoughts of innocence here in this case and unravel the full story for you. Now, with that, let's jump in to this Minnesota parole hearing.
Thank you.
No worries.
Hello.
Hello, sister. I actually got you guys. You sit up right over here for the camera.
Over here?
So Mr. Smith, if you want to sit here too. Fast, you sit there. So
Oh, they did?
Yeah.
You can sit right there.
Over to the other side of the
That's
table.
right. Thank you.
That's perfect. That's great. Thank you so much.
All right, wonderful. Good afternoon, everyone. Rebecca Holmes Larson, Executive Officer of Hearings and Release in the Supervised Release Board. We are here today to review Mr. Joshua Smith, who is present at the Minnesota Correctional Facility in Stillwater. Mr. Smith also has his advocate and sister, Rashawn?
It's Rashawn.
Thank you.
You're
So
welcome.
Ms. Rashawn Smith is also participating today. Here with me at the Minnesota Department of Corrections Central Office is our Commissioner and Chair of the Supervised Release Board, Mr. Paul Schnell, along with Board Member Joe Earhart, Member Andrew Larson, Member Cheryl Ramstead, Juvenile Expert Member Jody Nelson, and Juvenile Expert Member Donald Strufert. Our records indicate that on September 29th of 2006, a victim reported to police that on September 8th, 2006, she had been sexually assaulted by Joshua Smith. She reported that she had gone to his home in St. Paul, Ramsey County. Mr. Smith took her to the basement and kicked her in the head and forced her to perform oral and vaginal sex. On January 1st of 2007, just after midnight, St. Paul police were dispatched to the area of Payne and Lawson Avenue in St. Paul in Ramsey County on a report of a sexual assault and beating. The victim reported that she was walking. When she was walking, she was approached by a black male. After a brief conversation, she became uncomfortable and decided to leave. As she attempted to leave, he grabbed her by the neck and pushed her into an area between a dumpster and a wooden fence. He choked her and pushed her onto her knees and then forced her to perform oral and vaginal sex multiple times. He then forced her to another area where he grabbed her by the neck and began beating her about her face and head. She fell to the ground and he began kicking her about her head and face. She pretended to be unconscious and then he left. The victim had visible injuries to her head and face, including a 2-inch cut on her forehead. She was taken to the hospital and a sexual assault examination was completed. Oral swabs were then submitted to the BCA for testing. On March 1st of 2007, the results of the DNA testing were received and matched the DNA profile for Joshua Smith. On December 17th, 2008, Joshua Smith was sentenced to 43.25 years or 519 months imprisonment by Ramsey County District Court after having been found guilty of 2 counts of first-degree criminal sexual conduct. Due to new legislation regarding individuals who were juveniles at the time of their offense, Mr. Smith now has the opportunity to be reviewed by the Supervised Release Board after serving a minimum of 20 years of incarceration. Today's review by the board represents Mr. Smith's first review after serving approximately 18 years of incarceration. His original confinement release date is January 8th of 2036. His 20-year minimum eligibility date is March 9th of 2027. Thank you. I turn this matter over to the board. Commissioner?
Good afternoon, Mr. Smith. How are you today?
I'm doing good.
Good. I'd like to start by asking you what it is you'd like to see happen as a result of today's meeting.
Well, from my understanding is that this hearing is saying that I will be eligible to be released in 2027,
That's correct.
and that's what I'm hoping for.
And what do you think you need to accomplish in order to be ready for a release in 2027?
Well, I did get a list of mandates to complete before my release. Majority of those I've done. Only things that I haven't done is anger management, AA, and treatment.
And are you talking about SO treatment or?
Yes, sir.
Okay. So first and foremost, let me just, I want to make sure that I understand the record. Are you guilty of these crimes?
I do not feel that I am guilty.
Okay. Can you explain why?
The girl that you spoke of that I brought to my home, as she said, I did not attack her, did not bring her to my home. After midnight for the second crime, I've never met this woman ever. And this woman did not pick me out of the lineup. I was just told that somebody seen the sketch and said that looked like me.
What about the DNA?
The DNA, I don't know how they had a sample of my DNA if I never gave them a sample.
So let me just, but the DNA that was recovered off of your second victim, you dispute that that was your DNA?
Correct.
Yeah,
Okay.
because they say they found DNA in this woman's mouth, but yet there was no DNA found on the person due to the hospital's DNA or sex rape kit. And I do have proof of that. They found no substance on this woman whatsoever.
Okay. So you deny wasn't me, wasn't there, didn't do it on the
Right.
second one?
On both.
On both, yeah.
Oh, so in both instances, you're innocent.
Correct.
Yes.
Okay. That's all the questions I have.
I have a question. I'm looking at your report. It said that you engaged with approximately 20 to 30 people before you were incarcerated. And I'm wondering how you found those people
What was?
Where did you
Huh?
find your sexual partners?
Can you put some clarity to that question?
Yes. You estimated that you've had approximately 20 to 30 sexual partners. My question is, how did you meet up with, find, get to know, get together with these 20 or 30 sexual partners?
Did you ever say that you had 20 or 30 sexual
Yeah,
partners in your life?
I've been with more than a certain number, but it's people that was around town that I've met from school, neighborhood that we stayed in, or just people that knew people that I knew.
How did you pick your victims? How did you pick these people who are
There was no
alleging that you
victims.
assaulted them?
Ma'am, I'm just gonna, Rashawn, I just want to just make sure that we're focused. We'll get to you here in a second, but
Yeah,
I want to
but
make, I want to make,
understand.
no, wait a second.
Hold
So
on, sir.
we,
I understand.
we-
I just want to speak to what you're saying so I can help you understand.
I want you to stop. I want
do
you to
have
stop.
yell? Do you have to
Smith.
yell and be so aggressive
I want
towards
you-
me, sir?
Ma'am, I want you to stop or I will have you removed from the meeting because that's just the way this
There's
is. This
no
is a
need to
meeting.
be aggressive.
I'm
The
just
Russian is
saying.
not necessary. I'm
Okay.
trying to help him
Question is-
understand.
Wait,
From my
the
understanding,
question-
I'm here to be an
Ma'am,
advocate for him and he doesn't
Ma'am, we're
understand.
gonna end this meeting altogether with you if you want to continue.
But
We're
he
gonna be
doesn't
done.
understand and
For
it's my
Mr.
job
Smith.
to advocate for him, sir. There's no need to be aggressive. We need to be
No.
examples for the people that we are trying to
So-
teach lessons here.
So wait a
There's no
second.
need to be aggressive towards me.
No, so here's the deal. So you will have the opportunity to speak and speak freely. But until that time, this is a conversation with your brother. And that's how it's got to be. And if it's going to continue, we're just going to stop it and we'll deal with it another time.
This question is
that's
for
fine.
Mr. Smith and Mr. Smith alone. How did you meet up with the two people who had your DNA on their body or in their mouth? How did you meet up with those two people? One was an acquaintance, you said that. The other was a total stranger.
Yeah,
So how
I've
did
never
you
met the woman that was the stranger. The one that I knew, I end up meeting her again after years of not speaking with her through an acquaintance of someone that I knew and that I felt was a friend at that time. And we exchanged numbers and spoke on the telephone.
And how did you
But
get her
this other
to your
woman,
home?
I've never seen her, ever met her outside of seeing her in the courtroom.
Okay, let me just change course here a little bit. Are you willing to enter sex offender treatment?
If I have to, yes, I will.
And why would you enter sex offender treatment?
Because I want to be home with my family. I've lost numerous of relatives over these 18 years of me being incarcerated.
Do you
And my
believe that you
grandmother
could
is
complete
getting
the
of
program?
age.
Do you believe that
Ask
you
her to
could
repeat the
complete the
question.
program?
Huh?
Do you
Could you
believe
please
that you
repeat
could
that?
do you believe that you could complete the sex offender treatment program?
I believe I can.
Have you been involved in any sort of treatment related to sexual offending during your lifetime?
No.
Do you have any reason to believe that these women had a reason to lie about you?
Yep.
No, I'm not
The-
talking to you.
I'm speaking to Joshua. I'm not talking to you either, ma'am.
Ma'am, I'm gonna give this last caution, and this hearing is gonna be over, right? So last caution, when it's your opportunity to speak.
Can you tell me the rules? If I were
Yeah.
told the rules ahead of time, then maybe we wouldn't be having this miscommunication.
Okay, well,
I
I'm
think that's
telling you,
fair.
Okay, I'm telling you what the rule is. The rule is
Okay,
when
let me know
when
all
you're
of the rules so that way I
I-
can know straightforward. If you will, please.
this you are not permitted to be in a place to speak until we call on you and open the floor to you. The
So I
conversation
can't
is
speak to Joshua either. I
that's
need
exactly
to clarify.
that's exactly what I'm saying.
Okay,
You
but I
are
need
not
to clarify. Everyone's understanding is different, sir. I would hope
Okay.
people in your position would have more understanding of that.
okay.
I think all of you may even have degrees. You should understand that people need time to communicate. So
Okay,
you're saying
so-
something to me, so I'm trying to
All right.
understand what you're saying to me.
This meeting is going to
that's
be
fair.
over.
I have another question I'd really like to ask Mr. Smith. I'd like to find out about this. I see that you had a history of seizure activity. When you had seizures, did you lose consciousness?
Just, like pass out or
Yes.
I'm not understanding.
When you had seizures, the report indicates that you have a seizure activity disorder. Whenever you had
Right.
a seizure, would you lose consciousness? Would you lose touch with reality?
Not to my knowledge, no.
What would happen during those seizures?
I couldn't tell you 100% of everything that happened because I've had seizures while I was asleep. I've had seizures where my body seized. And from when I was younger, I couldn't tell you exactly what happened with those seizures.
Is it possible that your offenses were committed during or after a seizure?
I wouldn't say yes to that. No, I don't think so.
Thank you.
Other questions board members have for Mr. Smith?
Mm.
Okay.
Mr. Smith, I'm wondering what steps you've taken to prove your innocence.
I've tried to go back on appeals. I've tried to go through to the Innocence Project. I've put in a request to keep Ellison. I still haven't heard anything back from that. But the Innocence Project said because my case is based off DNA, they couldn't help me. I've went through the appeal process and I believe 8 or so months after they said that the Court of Appeals denied my appeal. They asked me if I wanted to go to the Supreme Court and I wrote them and told them that I would. And they wrote a letter back that following week saying that they denied my appeal also.
Just one more question, Mr. Smith. In looking at your report, you indicated that you would have memory loss after seizures and would not remember what happened. Is that accurate?
Yes, ma'am.
Thank you.
All right. Seeing no other questions, I'm going to turn to Ms. Smith to provide your insights and thoughts as to your brother's readiness for release and what you think he may need between now and the time of his minimum eligibility.
He needs to be released. That's what he needs. He needs to be released. And that's just it. These
All
are
right.
crimes that he didn't commit. His whole life, he was a child with special needs. And this state has taken advantage of him. And I'm highly disappointed in each and every individual involved. Those are my statements. The very same people whose job it is to uphold the law did the things that they did to my brother, who was a child with special needs. And they took advantage of him. And I'm highly disappointed. Just as she was asking him those questions, a lot of the stuff he barely even understood. He was trying to figure it out. There's no compassion at all. And the second someone tries to step in to help him understand, is shut down and shut up and be quiet and don't speak, met with aggression.
Just one more question, Mr. Smith.
I
Were
am
you
speaking,
using
ma'am.
drugs
It is my
at the
turn to
time?
speak. He asked Mrs. Smith,
Okay.
it's my
Go
turn to
ahead.
speak right now.
Go
It
ahead,
is my
please.
turn. You
Go
guys
ahead.
continue to do the very things that you ask other people not to do to others. I am trying for the life of me, for the love of God, to understand how people who are sitting here trying to force other people to behave well, but cannot fathom this very same good behavior themselves.
You through?
I am not, but thank you for asking so politely.
You're welcome. Mr. Smith, do you have a history of
Joshua
drug
needs
use?
to be released. He has given you all his entire life. Isn't that good enough? What else do you want from him? Since he has been here, since he was a child with special needs, with no one, his entire life since he was born, he has had seizures. He has never had a normal life. And then you throw him in a cell like a dog. He has cancer. You have robbed him of a life. These victims that you speak of, they are still living. They are still breathing. I have seen people murder people and get less time than this. It is highly unacceptable.
Are you through?
I am.
Thank you. Mr. Smith, were you using drugs during this period of your life?
I have, but nothing would alter my understanding of the situation.
Have you been advised not to use drugs due to your seizure disorder?
I have.
Is there anything else you'd like to tell us just in terms of what you think may be going on? I mean, you know that your DNA was found on these two victims. That's a fact. Anything else? you'd
That
like
is
to
not
tell
a
us?
fact. And you
Okay,
will
thank
not
you.
let these people, Joshua, treat you
Mr.
any different than what you know to be true. You do not listen to them. You stick with the facts that you know to be
Mi-
true. No one should
Mr.
force you to say anything other than what you know to be true. None of us were there.
Mr. Smith, I want to
You
just
only
open.
speak the truth. Do you hear me?
I'm gonna
Whatever
gonna
that
open-
is, speak that truth.
Ms. Smith, stop, please. Mr. Smith, I'm going to open the floor to you, provide one last comment before the board enters into deliberations and discussions of next steps. Anything you'd like to say or offer?
No.
No.
Okay. Thank you. And with that, we'll close that portion of the discussion and move into discussion of next steps.
I'm wondering if we could do a redo with a different advocate.
I
I don't-
believe we got some
I
information.
don't think
he
he
has the
got,
right
I
to-
don't, can I finish?
Sure, I'm sorry.
I don't think he got, I thought he answered well. I think he understood what he was being asked. He's got his reality that is his reality. And I just wonder how this would have gone with an advocate that was not so emotionally charged by this. I would like to hear more of what he has to say.
The reason I would oppose that is he chooses his advocate. I mean, that's his choice. I don't think we should
And yet there's also
interfere with,
whatever
excuse
she's
me, I
saying
don't think
about
we should
special-
interfere with that choice.
I'd also like to understand more about what are the special needs? Is he developmentally delayed? What, there's a familial thing. Yes, sorry. I mean, there's a familial thing going on here. And he may not have picked the best advocate. I mean, I think she's definitely advocating for him, but in this setting, you would want somebody to help him tell his story better.
Is there anything in the file to indicate developmental delay?
Well, it's special ed, but we don't get the,
But we don't
There's nothing
know.
beyond
education.
special ed.
And yet, clearly, he needs sex offender treatment. They have sex offender treatment, and they will determine which level he needs to enter and participate in. He said he would be willing to go to SO treatment. We, of course, deny parole at this point, direct him to enter and complete a sex offender treatment program and any other appropriate programming. I don't really think there's a lot that we could get out of this. We don't know everything going. He may need some psychological testing. Certainly he is receiving medical treatment now, but we don't know, and we don't really need to know about the seizure drugs and that type of thing. But a thorough program, a thorough assessment will look into all of that in terms of whether that could be a factor in this, and it certainly could.
The file indicates that he was accepted into a sex offender treatment program at Lionel Lakes, but not accepted, that he was not accepted. It was
I
offered
would not accept him.
because he denied it. I don't know if there's any.
Well, they do
Standard
have,
procedure.
Hmm?
That's standard procedure.
but they do
Right,
have,
so I don't
in-
know that it would be any different. if
they do
we-
have in different facilities, they have something called, at least they used to in Stillwater, a deniers group that people, if they chose to do so, would first go into, and you need to start somewhere with this. Certainly there's programming he can go to, but this is his outstanding need is treatment. And if there is such a group, I wish I knew, I wish I had a
There is
list of
not,
the
there
groups.
is
There no
not
longer
at
is.
present.
It may be that individual therapy would be a good place to start, because there definitely are some issues there that he needs to explore. And the individual therapy directly with him would be a good start.
We've got, what, two things on the floor right now? Your request to consider the opportunity for a second advocate and your proposal of particular steps to continue.
To deny parole, and because I can think of nothing better at this point, if TSOP will not take him, individual therapy to address his seizure disorder, his psychological well-being, and any impact that this could have on his offenses.
I understand that. You see no benefit for a second opinion or another opportunity for inclusion of another advocate.
What would be the best case scenario?
well, I would like for him to have the experience that I think most people have with us, which is a lot of respect. Hearing from us in a way that's not so adversarial, given, what his advocate has showed up in that way. I would just like him to have the opportunity to engage with us in everything you're saying. I'm in agreement with.
We
I
can't
just
force
think
him
it's-
to have
I
a
think it's-
different advocate.
I think it's just unfortunate, or even come by himself, to hear and engage with us in conversation about what and why our plan would be.
So I'm troubled just by the door itself of denial, and because that makes it really hard to figure out what the moves are.
It's not that unusual.
I understand it's not
used to
unusual.
take deniers into treatment because sometimes they need the support of others. Sometimes they need to think about it more in depth and look at the circumstances and think, well, I need to think about that more clearly. I wish they did. I can't make the program take anyone that they've refused. I wonder if we could ask them to reassess that decision.
I mean, I think there was at least the last we had that conversation in-house was, the efficacy of the treatment, I think became a question from a research standpoint, if there was a denial. And I think that was the underlying, I do also hear the range of concerns about, needs and having a better understanding of special needs, whatever the seizure disorder implications, whatever that looks like, and the other range of programming that it could be beneficial in terms of moving them forward.
Yeah, I'd like to see them move forward.
I guess I just don't know. I mean, I want to address this question of, would seeing him again with a different advocate or without one, would that change the next steps discussion? That's what I'm trying to struggle with here. And I
mean, he's created he's in a rock and a hard place. He doesn't think he's a sex offender. And yet we're pushing sex offender treatment. He does want to get out. So he'll go for sex offender treatment and he doesn't believe he's a sex offender.
Well, we have other people that we see who do not believe that they committed the offense for which they're incarcerated. It's not unusual.
I've been specific to sex offense. That's what I'm talking about.
And that's not unusual.
Sorry.
Because otherwise nobody else can.
Yeah, sorry. Yep.
I would wonder if there's maybe an opportunity. So there are two unmet treatment directives. There's SUD treatment, and then there's also the sex offender stuff. And I understand he's maintaining his innocence, and so I'll not even go down that road. I'm wondering if the focus is on the SUD treatment initially, maybe if that would, maybe kind of open, maybe that would address some of the things that we have been discussing. So, and may kind of start to foster that more rehabilitative, treatment-oriented mindset. So I would maybe just kind of put that out there as, because I agree that sex offender treatment piece is going to have to be something that's addressed. It just is. Our role is not to determine his guilt or innocence. That's what the court
I think
has
you
done.
make a really good point. The treatment.
So I would wonder if maybe that's, so maybe that's the route we go in terms of recommendations, and then bring them back in, whether it's whatever. I know it's been said treatment can typically be 14 months, 18 months, whatever. So maybe we set it for, a 30-month continuance to allow time for completion of SUD treatment, come back, and hopefully the experience is better, and then we can readdress the sex offender treatment piece at that time. Just a thought.
He's actually on the waiting list at Stillwater and scheduled to begin the Atlantis program on July 25th.
Oh, good.
And it's an 8-week program, according to the records that we've got before.
I think that's the anger management treatment
No,
or anger management
it's
programming.
Yeah, I think
Well,
that's right.
they must have confused the two because
Yeah, Atlantis is 12 months.
I have recommended anger management non-waiting list as well.
My notes say Atlantis program 3/9/26, 12 months. Anger management, July, 8 weeks.
So there's nothing in the file to indicate he's applied for chemical dependency treatment or,
Atlantis program, 12 months, 3/9/26.
okay, so that's the only difference. Is he on the waiting list
I think so.
for the same date I mentioned?
Was it 3/9/26?
Yes.
Yeah. I like what Andrew's proposing. Is that a
Thank you.
motion?
I can certainly make that a motion
all right,
if it
there's a
was
mo-
clear enough for a motion.
You want to just restate to the extent
Sure,
possible?
I'll attempt. I'll attempt. So my motion is to deny parole. Set a continuance of 30 months with the condition that he successfully complete the SUD programming, which he is already on the wait list for, as well as the anger management programming, which he is already on the wait list for. And then obviously the standard conditions of no rule violations, and really encourage any other pro-social programming between now and when we see him again in 30 months.
All right, there's a motion, and is there a second?
Seconded.
Motion and a second. Any other discussion? Hearing none. To the motion, Board Member Earhart,
Agree.
Board Member Larson,
Yes.
Board Member Ramstead,
No.
Board Member Nelson,
Yes.
Board Member Strufert,
Yes.
Schnell will vote yes. The motion prevails. Mr. Smith, you've had a chance to hear the discussion. We would be looking to work with your team to get you into treatment as kind of proposed and that programming, and then would see you in 30 months. And just in the meantime, would encourage you to remain discipline-free and participate in any kind of positive pro-social programming that may be available to you. Any question about that?
No.
Okay, thank you so much. Good luck to you.
Okay, we are still live, just so everybody knows. Do we know if we can get our work release here yet? Okay, should we take a quick?
Yeah, let's, we'll go on break
The
status.
correct one's here and I just
and we go
misread
from
it.
there.
Oh, yeah. Yeah. You know, I actually.
So
Okay,
The
in a
board,
quick break.
will move into a break.
Okay. And I was hoping that they would have a hot mic session where we could hear what they truly thought, but they were smart enough to know not to do that. But they did take about a 15-minute recess. I think everyone needed to collect themselves after that just insane performance by his advocate, by his sister. And there are some people, they're just so far gone. There's no arguing, there's no talking, there's no dialogue, there's no conversation. There's clearly something very wrong with her. She's yawning during this proceeding. She went in there trying to fight this. Do you not have any common sense that what you are doing is clearly hurting your brother? Not only are you not an advocate for your brother, you are the worst thing that ever happened to him. It's because of you that he's not able to just get out at parole, right? It's because of you that he's refusing to take culpability. It's because of you that he still thinks in his mind that he is innocent. It's because of you that you are the reason. If he has this special needs, it's you that are tapping into that vulnerability where he can't think for himself. You have very serious issues, young lady. And it's crazy. Then she goes on to even say, where I guess it's at a point where she does admit that he has victims. And she says, they're still alive. Who cares? They're still walking around. I've seen people get less time for murder. Wow. You're not the victim, lady. Your brother is not the victim. The two people he essayed and nearly killed. We'll go over the facts of the case. We have it from Lady Holly. These were not just an SA. These were violent, brutal offenses that could have resulted in death. The 50-something-year-old woman had to pretend she was dead to get away from him. They had DNA. They took this to trial. This was no plea deal. There's no, maybe there was a mistake in the identification. They had DNA. He is one of the most dangerous type of predators that can exist. He does not discriminate on age. One of his victims being a special needs kid, his age. Another victim being a 56-year-old mother. This is all done when he was 17 years old. And I think the math tells us that people don't get caught 100% of the time. Maybe that's what one of the board members was alluding to when he said he had 30 or so sexual partners by that age. I don't know what she was alluding to with the seizures. Is she trying to buy him an escape or trying to lead him to admitting guilt, but maybe with less call? I don't know. But these were not like, oh, I forgot. And for those of you who don't know, I don't take the special ed thing lightly. I'm special ed. I took the short bus to school. I never in my entire life, from any grade until I dropped out in high school in the 10th grade, had a passing report card. I do not know what it is like to pass a test. I don't know if it's ADD, if it's dyslexia. I was diagnosed with both, but I really don't. I'm still to this day, I'm not even sure. This was back in the, in the 90s when they're trying to diagnose me, and things have changed quite a bit since then. They thought it was my eyesight. You could have the stuff I had to go through with the testing. Wow. Someone, the problem is you can't fix this, right? No one can talk to the sister. The sister will always be the advocate. She will be the one probably preventing him from getting out, which probably is the best thing for the world. Imagine him getting out. This is not something that he'll take a sex program. If he takes it, it's not going to help him. Come on, guys. You can't fix this. But they do let people out. And we covered a case in Connecticut where he was arrested. The woman on his left, who was like 90 years old, mysteriously died. The woman on his right, he lived in a middle house. So he had a house who was also in her 90s, died, but they caught him for that crime with DNA. And they realized that he had essayed and killed her. And then the detective said, wait a minute, this is too similar. Let's exhume the body of his other neighbor. They did, match the DNA, so we know he essayed and killed 2 women, and he got paroled. We covered his parole revocation hearing because he got revoked because he was disappearing. He cut off his leg monitor and would disappear for a week at a time. That's in the Connecticut playlist and channel Mandoo 2. I have 2 channels. You can check that one. Yeah, it's scary. Scary. He was sentenced to 1,000 years in prison, but they paroled him. And they probably will parole this man as well. And who can predict what's going to happen next? Now let's go over the information that Lady Holly has. Here's the appeal. And there's more than just the appeal, but we'll go through it all. So he was convicted of a first-degree criminal sexual contact and violation arising out of attacks involving 2 victims. The first offense occurred on September 8, 2006. The 16-year-old Smith invited the 17-year-old victim to his home. AJE is developmentally delayed and functions at about the age of 12. So he took advantage of someone who functions at the age of 12. This is his first victim. Smith forced her to perform on her by taking and threatening not to return her cell phone. Smith forced AGE to remove her clothing by kicking her in the back of the head 5 or 6 times. Smith then penetrated her. EJE's mother learned about the assault when he confronted her daughter about changes in her behavior. EJE had saved the blood-stained underwear she wore on the night of the attack, and her mother turned it over to officers of the St. Paul Police Department. The sex crime investigator identified Smith through EJE's description and telephone records. The nurse who examined EJE noted that EJE had 2 complete claustral hymen, a sign of penetration trauma that is evident in fewer than 5% of SA assaults, the nurse investigates. Now, the second offense occurred New Year's Eve, 2006, 2007. 55-year-old DLK was walking home and stopped in a parking lot to smoke shortly after midnight. Smith approached her and made small talk. As DLK turned to leave, Smith grabbed her by the neck and said, "You're not going anywhere, bitch," and pushed her behind a nearby dumpster. Smith pushed down his jeans and shoved his thing into her mouth. He then essayed her. DLK was terrified and unable to effectively resist Smith because of his size. Smith then hit and choked DLK. She remembers being dragged and placed into a truck under garage, out of public view. Smith continued to kick and stomp DLK until she decided to play dead. This is the poor, innocent victim brother who was wrongfully convicted and sent to prison because his victims are still breathing and walking around. Once she stopped moving and pleading, Smith left. DLK ran out to the street and stopped the first car that she saw. She had blood pouring out of a gash on her forehead, significant swelling around her left eye, and a broken nose. She also had injuries on the back of her head consistent with being thrown to the ground and genital areas consistent with SA. DLK told police that her attacker was wearing dark clothes with some orange near the top. A neighbor reported that she saw the tall figures dragging something in the parking lot around at the time of the attack, and that the person rode off on a bicycle about 10 minutes later. The officer secured the scene and found a condom, wrapper, bloodstains, bicycle tracks, and a discarded condom out of the dumpster. 3 days later, DLK met with the forensic sketch artist. The sketch artist bears strong likeness to Smith. On the evening of the second offense, Smith was at his girlfriend's house, which is located about 5 blocks from where DLK was assaulted. A friend who was with Smith reported that he left his girlfriend's house on a bicycle around 12:15 a.m. DLK is 4'9". Smith is 6 feet tall at the time of sentencing. Same friend testified at trial that when she saw the forensic sketch on television, she identified the subject as Smith. So they did a sketch, and she said, "Hey, that's him." Smith's girlfriend stated that he did not leave her house until 1 or 1:30 a.m. and that he was wearing dark clothes, a dark jacket with a bright orange lining. DNA evidence links Smith to both victims. And they're like, "How did you get the DNA?" "I don't know. They got it from the victim." Like, again, I can't get over how insane the whole thing is. You're up here at a parole hearing. Because of a new law that passed that said that you were underage, you now have the chance of parole. You can get paroled in 3 years. And what do? It makes no sense. Even if you thought he was innocent, even if he was innocent, this is not the venue to say any of that. You would just say, "Yes, we did it. This is," and you'd be getting paroled. Oh, it's like, what is wrong? So many people are broken. A DNA sample from EJE's underwear matched known sample from Smith's DNA and DLK's oral swab from the condom found on the scene of her assault match. The male DNA in EJE's underwear and DNA sample. The Bureau of Criminal Apprehension estimated that the statistical likelihood of obtaining such a match is 1 in 100 billion. Guys, there's still a chance. I know I'm special ed, but the math in me knows that this means there is technically still a chance, even if it's less than 1 in a billion, there is still a chance it wasn't him and he's innocent. Right? Smith retained Lawrence Mueller's PhD, University of California of Irvine, to refute the DNA evidence. Dr. Mueller's expertise in statistics and here we go. We got the experts in here. Can you imagine selling your soul where you show up because you're paid by the state, taxpayer dollars, to show up and be like, "I am a doctor, I am a PhD, and my expertise in statistics and population genetics state that the challenge in Dr. Mueller's proposed testimony on the ground that he was not disqualified about DNA." I don't know what they're saying, but it's just ridiculous. Okay. How uncertainty of the laboratory performance impacted. Shut up. I really don't care. The jurors found Smith guilty on both charges. The jury then found in a separate proceeding that the 3 aggravating factors present in respect of DLK's SA, particularly vulnerability due to sizable forms of penetration, unnecessary cruelty. The district court imposed guidelines of 173 months on the first-degree criminal conduct. The district court sentenced Smith to 346 months of double upward departure on the offense to be served consecutively. The district court imposed, but they're having him come back in 3 years, right? Or yeah, I think 3 years. And if he comes back with her and not taking his programs and not admitting guilt, they're not going to release him. And there's nothing that would tell us that she's not going to continue making sure he stays in prison. This is him at the time of the crime. Let's see what they say here. 2 accusations, 2 victims, 2 guilty verdicts. Early Tuesday evening, after more than 4 hours of deliberation, a jury convicted Joshua Lamar Smith, 18, of essaying a 57-year-old woman and a 17-year-old girl, but it didn't end there. After brief arguments, let's see if I can zoom in more for you. After brief arguments by the attorneys on each side, they recessed again, then returned to the courtroom with another decision. There were aggravating factors in both St. Paul's cases that would allow the judge to sentence Smith for a greater time than recommended under state guidelines. Joshua Lamar Smith's girlfriend testified that he was in her home on New Year's Eve. The older victim said that he was less than a mile away, essaying her in a dark parking lot. 2 days after that, the victim worked with a police sketch artist to create a drawing of the suspect whom she did not know. Police put the sketch out to the media, hoping that someone would recognize the image. Someone did. The girlfriend called her friend Hannah, fearing when she saw the sketch on TV's Fearing testified. Josh is on the news, Jones Gray told Fearing. But Jones Gray did not go to the police. She did not talk to them until more than a year later, February 2008, when she told the sergeant that she was sure Smith was at her house until 1 or 1:30. The 911 call about the SA came at 12:40. By the time she talked to police, Jones Gray knew that Smith had been charged with the SA, and he had written her letters from jail. Prosecutor Heidi Wetsby said, "You love this defendant, don't you?" "Yes," she replied. Jones Gray was called as an alibi witness for Smith, who faced 2 charges of first-degree criminal SA. In the trial, Smith was 16 at the time of the incidents, but was later certified to stand trial as an adult. The Pioneer Press generally does not name victims of SA. Prosecutors summoned up to the case Tuesday. The 17-year-old girl and Jones Gray knew each other from junior high school. Both testified. The girl happened to see Smith as Park some days before her alleged SA. They exchanged cell phone numbers. Smith called later on September 8, 2006 and invited her to his house. She told the jury she thought they were going to just hang out. Instead, the girl said Smith forced her to perform, kicked her in the head, and then essayed her. Afterwards, he walked her back to the bus stop, warning her not to tell anyone about what happened. The defense said both victims gave conflicting testimony. The older woman cannot recall whether she initially told police that she had encountered Smith on Pear Avenue or in the Salvation Army parking lot. On the witness stand, she said that she remembered being essayed in the parking lot. I think so this is just them, going with it. Also called into question the DNA results, which tie Smith to both incidents. The prosecution argued that the girl's confusion at certain points could be attributed to cognitive shortcomings. She had an IQ of about 58. Her mother testified that she became painfully clear when she gave her own body parts to name the male parts. Has she ever wavered on the basic facts in this case? Prosecutor Heidi Wetsby asked the jury. She absolutely has nothing to gain by coming to this court. Sentencing scheduled.
Daddy, my tutor's here. I need you to unlock the door.
Okay.
Daddy.
Okay, well, my daughter's tutor just came, so I will be going, but wanted to finally end with the Lady Holly's work that she put in here, pulling in all the articles, the information. Lady Holly's always on the case, and she's suffering right now with different illnesses, and so she's just a champ. It's amazing. Let's look at Lady Holly's random fact of the day. It's illegal to yell at your children at a drive-in Arkansas restaurant. This law is definitely archaic, as you'll find if you go to any Central Arkansas fast food restaurants on any given weekend. I love it. These laws are ridiculous. Someone actually puts them in writing. But you know, this was obviously Minnesota wanted to lock him away for a long time. He has like the attributes and the signs of someone who would be a serial predator, and I think that's why they wanted to lock him away for so long. The different age in the victims, the unnecessary violence, the idea that he could be released at any given time, I think is horrifying, and pretty much as horrifying as him having that advocate that was just absolutely, it's just totally nuts. They need a way to kick someone like that out of the room, right? There needs to be something to prevent it. But we've seen thousands and thousands and thousands of parole hearings. We've never seen that. I wonder if we'll ever see it again. And with that, I'll let you go.
These victims that you speak of, they are still living. They are still breathing. I have seen people murder people and get less time than this. It is highly unacceptable